Greetings to you all. I am Tanya Pandey for Live Law, welcoming you to today's episode of Courts This Week. If you're watching our series for the first time, you will be hearing about all the latest judgments from different courts in the country, so do subscribe to Live Law and click the bell icon for regular updates. Let's begin today's episode with judgments from the Supreme Court. The Supreme Court on 29th July issued notice in a special leave petition challenging a final order of the Allahabad High Court, contending that the High Court adjudicated upon identical legal issues involving interpretation of Rule 9 of the Motor Vehicle Rules 1989, which were already pending consideration before the Supreme Court in New India Assurance Company Limited versus Lakshmi and others. The petitioner submitted that the Allahabad High Court had disregarded diametrically opposite views taken by various other high courts, wherein it was held that in order to drive an empty tanker, endorsement on the driving license to this effect is not required, as the phrase carrying under Rule 9 of the Motor Vehicle Rules must be taken into consideration. The Supreme Court has observed that an arbitration award which ignores vital evidence in arriving at its decision or rewrites a contract is liable to be set aside under Section 34 of the Arbitration and Conciliation Act on the ground of patent illegality. Justices Arif Nariman and B.R. Gavai observed that a finding based on no evidence at all or an award which ignores vital evidence in arriving at its decision would be perverse. Rewriting a contract for the parties would be breach of fundamental principles of justice, the court said. In this case, the appellant had challenged an order of the Madras High Court, which had allowed the appeal of the respondent and set aside the award passed by the arbitral tribunal. Referring to Section 34 of the Act and its judgment in Associate Builders versus Delhi Development Authority, the Supreme Court explained the test of perversity and observed that the arbitral tribunal's findings were based on no evidence and ignorance of vital evidence. The court further found that the award had created a new contract for the parties. Accordingly, the bench said that the award would come under the realm of patent illegality and therefore was rightly set aside by the High Court. The Supreme Court has reiterated that there is no requirement of examining the complainant on oath under Section 200 of the Code of Criminal Procedure before a judicial magistrate orders police investigation under Section 156 Clause 3 CRPC. Accordingly, the Supreme Court set aside an order passed by the Bombay High Court, which had granted anticipatory bail on the ground that the order of magistrate to direct registration of FIR under Section 156 3 CRPC was given without examining the complainant on oath, as under Section 200 CRPC. The bench of Justices D.Y. Chandrachud and M.R. Shah referred to a line of precedents which held that Section 156 3 CRPC is a precognizant stage and held that the High Court's view was erroneous in law. The Supreme Court has observed that a court cannot stipulate that other sentences would begin after expiration of life sentence awarded to a convict. In this case, the trial court had convicted the accused under provisions of the Indian Penal Code, Explosive Substances Act, Unlawful Activities Prevention Act and Arms Act. The trial court had directed that the sentence of imprisonment for the offence punishable under Section 5B of the Explosive Substances Act 1908, which is the rigorous imprisonment for 10 years, shall commence at the expiration of life imprisonment for IPC offences. The High Court of Karnataka had upheld the conviction and sentence awarded to the accused. Before the Apex Court, the accused appellant contended that such a direction was contrary to the decision of the Constitution Bench given in Muthu Ramalingam case. Agreeing with the appellant's contention, the bench of Justices Uday Umesh Lalit and Ajay Rastogi modified the sentence part of the trial court's order. Ocular evidence is considered the best evidence unless there are reasons to doubt it, the Supreme Court has observed, while setting aside an order of the High Court that acquitted an accused in a murder case. The bench of Justices Naveen Sinha and R. Subhash Reddy observed that ocular evidence may be disbelieved only when there is a gross contradiction between medical evidence and oral evidence, and the medical evidence makes the ocular testimony improbable and rules out all possibility of ocular evidence being true. In this case, the High Court had reversed the trial court order convicting the accused on the ground that the evidence of the eyewitnesses is inconsistent with the medical evidence regarding the nature of injuries vis-a-vis the weapons of the offence. While restoring the conviction recorded by the trial court, the bench said that the acquittal by the High Court was based on misappreciation of evidence and the overlooking of relevant evidence, thereby arriving at a wrong conclusion. While refusing to allow the withdrawal of criminal prosecution against 6 LDF members in the Kerala Assembly ruckus case of 2015, the Supreme Court made certain significant observations on the scope of legislative privileges and immunities. The state of Kerala and the accused persons had raised an argument that the criminal prosecution was not sustainable against the members for acts committed in the floor of the Assembly, as they are protected by legislative privileges under Article 194 of the Constitution. Rejecting this argument, the Division Bench of Justices D.Y. Chandrachud and M.R. Shah observed that legislative privileges cannot be claimed to seek exemption from the application of criminal law. The court also formulated principles on the withdrawal of a prosecution under Section 321 of the CRPC. The court observed that while deciding a plea to withdraw prosecution, the court must be satisfied that the grant of consent subserves the administration of justice and that the permission has not been sought with an ulterior purpose. Seniority cum merit means that given the minimum necessary merit requisite for efficiency of administration, the senior, though the less meritorious, shall have priority, the Supreme Court has reiterated. In this case, the appellants were promoted to the post of leading fireman under the Bhakra Bees Management Board Class 3 and Class 4 employees, Recruitment and Conditions of Service Regulations 1994. The promotions were annulled by the High Court while allowing a writ petition filed by another employee who was junior to them. The High Court held them to be ineligible for promotion under the regulations. In appeal, the Supreme Court noted that the relevant regulations provided that appointment by promotion is to be made by selection based on seniority cum merit, and no employee is entitled to appointment as a matter of right. The Supreme Court has reiterated that brief reasons must be given in an order disposing an application for leave to appeal under Section 378 of the Code of Criminal Procedure against an order of acquittal. Merely observing that the order of the trial judge has taken a possible view without an application of mind to the evidence, and the findings are not consistent with the duty which is cast upon the High Court while determining whether leave should be granted to appeal against an order of acquittal, the bench of Justices D.Y. Chandrachud and M.R. Shah said. Now it's time to get the top updates from the High Courts and other courts. Stressing that there is no place for religious fanaticism, greed and fear in our country, the Allahabad High Court recently observed that if a person from the majority community converts his or her religion after getting insulted, then the country becomes weak and the destructive power source benefits from it. The bench of Justice Shekhar Kumar Yadav, who is dealing with the bail plea of one Javed, who had been accused of unlawfully converting a Hindu girl to Islam, fraudulently for the purpose of her marriage with the accused. Denying him bail, the court noted that it was clear that the conversion of the girl had been done for the sole purpose of her marriage, and that too against her will. The Delhi High Court has held that since the court is empowered to examine the grounds for rejection of plaint under Order 7 Rule 11 at the pre-summons stage, it can hear a defendant who is physically present in the court even though no summons have been served on him or he has not filed a caveat under Section 148A of the Civil Procedure Code. Referring to the judgment delivered by a division bench of the Delhi High Court in Bright Enterprises case, the court reiterated that the summons is not required to be issued where the suit is liable to be returned under Order 7 Rule 10 or rejected under Order 7 Rule 11. The Delhi High Court refused to quash an FIR involving rape charges against a man after observing that subsequent marriage between a man and a woman does not waive off the offence of rape. It was a case of the petitioner that the woman had lodged an FIR in the confusion that he committed forcible sexual penetrative assault on her after taking her to a room in a hotel. A single judge bench of Justice Mukta Gupta dismissed the petition filed by the man seeking quashing of FIR, observing that the offence punishable under Section 376 IPC being a serious offence, the FIR in question cannot be quashed on the basis of a compromise between the parties. The Jharkhand High Court has taken suo motu cognizance of the death of Additional District Judge of Dhanbad District, Uttam Anand, who was hit by a four-wheeled vehicle in broad daylight on 28 July 2021. As seen in a surface CCTV footage, Judge Anand was out on a morning walk when a vehicle deliberately hit him near the magistrate colony in Dhanbad. The bench of Chief Justice Dr. Ravi Ranjan had issued the order directing the SSP Dhanbad to remain present before the court. The Madhya Pradesh High Court has recently held that jurisdiction under Article 215 of the Constitution of India cannot be exercised to make Section 20 of the Contempt of Courts Act 1971 OTOs. The bench of Justice Vishal Bhagat further ruled that Article 215 of the Constitution and Section 20 of the Contempt of Courts Act are to be construed harmoniously, and only in an exceptional and blatant case of contempt, the High Court can exercise power beyond the 1-year limitation period. In this case, the petitioner before the court had filed a contempt petition for voluntary disobedience and breach of an order dated May 11, 2017. Noting that the petitioner had approached with his contempt plea after more than 3 years, whereas Section 20 provides for limitation for filing contempt within 1 year, the court said that ordinarily it can't go beyond the mandate of Section 20 of the Act. Additional Sessions Judge Dharmendra Rana on 29th July sent Raj Singh Gehlot, owner of the Gurugram-based Ambience Mall, to Enforcement Directorate's remand till August 5th in connection with a money laundering case for allegedly siphoning off the loan amount and diverting funds while entering into a criminal conspiracy. The court observed that the material available on record suggested that Gehlot entered into a criminal conspiracy with other accused persons to fraudulently siphon off the loan amount by diverting the funds for the purposes other than for what it was released. That's all for today's episode. I am Tanya Pandey and you're watching Courts This Week on Live Law. I wish you a wonderful week ahead.
Subscribe to our channel and press the bell icon to never miss a video from Live Law.